Hello, everyone, and welcome to today's Scholarly Skills webinar on Intellectual Property, or IP, What You Need to Know. My name is Alice MacLachlan, and I am the Dean and Vice Provost of the Faculty of Graduate Studies here at York University. I'm joined today by two of York's experts on the topic, Joseph Turcott, Associate Director of the IP Innovation Clinic at Osgoode Hall Law School, and Alison Collins-Marakis, Director of the Office of Research Ethics in the Office of the Vice Provost, Research and Innovation at York. Together, we are delighted to take you through the fascinating and sometimes thorny topic of intellectual property as it applies to graduate students, and to answer as best we can some of your questions, some of my own, and have a bit of a discussion at the end. Just so you're aware of the mechanics at the webinar, if you have any questions, you can enter them into the question and answer function. The panelists will receive them and we'll address as many as we can at the Q&A at the end. I can't promise we'll get to all of them, but hopefully the resources, links, and various supports that we share, as well as our own thoughts and answers, will help you answer these questions in your own time, if not within this hour together. I want to start, as is our custom at York, by taking a moment to acknowledge this university's relationship to the land on which it is housed. Since today's event is virtual, you may be in very different places and spaces and sitting on very different land around the area known as Canada or Turtle Island, or indeed around the world. So I invite you, as I give this land acknowledgement, to take a moment to think about the history, the stories, and your relationship to the land on which you are seated today. For now, I will say that York University recognizes that many Indigenous nations have long-standing relationships with the territories upon which York University campuses are located. These precede the establishment of the university. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Takaranto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It is now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject of the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. And of course, with this acknowledgement, we are reminded of the importance that agreements and understandings have had in the history of our land. And I think you'll find that today, as we discuss intellectual property, agreements and mutual shared understandings and records of those understandings play a tremendous role in our topic as well. So I want to give you a quick overview of today's webinar. We'll start at the with the biggest question of all: what is intellectual property? And then how it applies in your context, namely as a graduate student. And I put this quite bluntly: do I have IP rights? What do IP rights mean to me as a graduate student? I'll then go over some key tools and documents that are available to you as a graduate student at York that I think are crucial for helping you know, understand, and think about IP in relation to your graduate research and your work in the research of others, and also help solve potential problems before they arise. We will then talk a little bit about some of the problems that can arise in relationship to IP. I will explain the dispute resolution process that exists in the Faculty of Graduate Studies, and Alison, our Director of the Office of Research Ethics, will talk a little bit about what IP is and isn't in relation to research ethics. And at that point, we will really open things up. I have some questions to ask the experts. I imagine you have some questions as well. So that's when we'll turn to Joe and Alison to get their thoughts on IP and graduate research. And then at the very end, the slides will come back as I give you some further resources and useful links to you going forward. As we go, you will see links in the slides. That's of course frustrating because you cannot click on your screen to get the link, especially if you are on YouTube. Our FGS amazing support staff will be posting links in the chat for those of you who are watching this live. If you are not watching this live, if you are watching this on YouTube, what I will say is I have double checked. If you enter the text of each link into your search bar, the appropriate link will come up. So you can just write down the text, enter it, and you will find the links that are provided. So let's start with the big question. What is intellectual property? This is actually sorry, I should have started by saying I'm a philosopher by training. So I absolutely love big what is questions, but I'm going to try not to let that get the better of me today. And instead start with some commonly understood legal definitions, scholarly understood definitions, and frameworks as they apply in Canada. My sources and resources for this have been a number of scholarship on IP that has emerged out of York, and particularly out of Osgoode, which is a sort of leading school when it comes to IP law and the development of IP law, and also a handy resource that I will be flagging later for all of you, and that is the Canadian Association of Graduate Studies guidebook around IP and graduate students. So what is intellectual property? Intellectual property has to do with products of the human intellect. And here's where I do let my philosopher background show a little bit. Our understanding of property rights in the West can be traced largely to 17th century philosopher John Locke, who talks about how we gain property rights when we mix our labor with the materials out in the world. So if you till or plow a field, that field may become your property in some sense. Interestingly, that early definition of property has been picked up by IP scholars who talk about us mixing our labor of the intellect with the materials, and thus gaining with sort of materials out in the world, including inspiration and so on, and thus the product of that intellectual labor, not the intellectual labor itself, but the product of that labor becomes something over which we can claim intellectual property rights. We have the products that of our intellectual labor, of our thinking, creativity, imagination, research, scholarship, and so on. We can have IP rights over them if they are unique, novel, and unobvious to someone who is skilled in the field in which we develop them. So not everything you do is something you have IP over if it's been done a million times. But if your intellectual labor goes into making something, an expression of an idea of some kind, a product out in the world that is unique, novel, and unobvious to someone in the field, you may have intellectual property rights over that subsequent product. So inventions, artistic works, designs, and so on. One handy way to think about this is we have IP rights over the existing expressions of our ideas, but not over an idea itself. So what are some examples of things over which someone might have intellectual property rights? Literary creations, a unique name, a particular business method, an industrial process, some new software, a new drug, a genetically engineered organism, chemical formulae, electronic software, and relevant to most of us in academia, presentations and publications. Now, what do IP property rights look like in the law, or sort of when they're out there in the world? There are typically 4 types of statutory IP protection. Patents, which protect inventions, trademarks, which protect brand identity, designs, which protect product appearance, and copyright for material. So by this, I mean written material, artistic material, multimedia, sound recordings, films, and so on. So that's what IP is. How does it apply to all of you as graduate students? And in particular, do I have rights on IP? What does IP mean for grad students? And here's something I really want to emphasize. As a graduate student, as a scholar engaged in advanced study at York or elsewhere, you are a creator. You are an active scholar and creator. And thus, unless you're really not doing anything at all for your degree, you likely have some IP rights and rights to protection under copyright law or potentially patent law once you start to produce things out in the world. Now, I want to be careful here. As with everything, there's a lot of caveats and limits and conditions and variables here. And the nature and extent of these rights will depend on the nature of your scholarly research or creative activity, so what you're doing, disciplinary conventions. So one of the best examples of this is conventions around authorship. In the social sciences and humanities, where I come from, single authorship is typical. It's not uniform. There is co-authorship and there are multi-author publications, but particularly in the humanities, it is quite common to expect that publications have a sole author. In many STEM fields, for example, and increasingly in social sciences and other forms of interdisciplinary work, it is more common for publications to have multiple authors, many authors, and there may be conventions around first authorship, final authorship, or how to understand different contributions to a scholarly project and what that means for both authorship and, if you like, ownership over that project. And so it's not enough to say, well, I'm a scholar, therefore what kind of IP rights I have. One of the first questions would be, what are you doing and what field are you doing in? And what are the conventions, expectations, norms, practices of that field and of the kind of particular activity that you're engaging in? Also relevant will be university regulations and Canadian law. These will also play a role in shaping the nature of particular claims to IP rights that you may have. One that's particularly important for graduate students is the conditions of creation. And that's because graduate students have a number of different roles at the university. And I know you're all aware of the many hats that you wear already. You are students, but many of you may be TAs. Other of you may be working as different kinds of assistants, whether those are described as GA, General Administrative Assistants, or as RAs as part of your research activity. You may also be invited as collaborators into the work of others, including other graduate students and your supervisor or other professors who are PI or primary investigator or co-investigator over an ongoing research project. So graduate students in particular, because of your particular stage of scholarship and your role at the university, may find yourself simultaneously working on your very own research project that is yours, but also that research project may be part of your supervisor's bigger research project. Or you may be working as a paid assistant on your supervisor's research project on something related to your own master's or dissertation work. That is part of your degree requirements, but is also at the same time part of your supervisor's work. And you may be doing so in a paid or unpaid context. You may be doing the same task and bringing in the results of that analysis or that particular lab work for your own master's research or PhD research. And at the same time, that may be being used for other purposes in your supervisor's ongoing research project. I mention all this to flag, and I hope if you have one takeaway from today, two takeaways. It's complicated, and it's important to talk early and often about what, the ways in which it's complicated, and make sure you and your supervisor and any collaborators are on the same page. And if possible, please make sure that page is written down. If you don't have time for this webinar and you need to go at your lunch, those three things. It's complicated. Make sure you're on the same page as every other collaborator and write down that understanding so you all have a record of it. I see Allison nodding, and I always feel reassured when Allison nods at me, so I know that's good advice. It may also play a role what facilities you're using. Are you doing that research at the university? Are you doing that research in partnership with private industry and using their facilities? This may also play a role in what your IP rights are. And tied to that, the terms and conditions of any funding bodies. Many of us at York have our funding either through York or through the government, through tri-council agencies. These tend to leave ownership and authorship with the primary investigator, with the person doing the work. However, in some fields, you may find that you're doing research in partnership with private industry or with industry sponsors. And there may be implications for the intellectual property of any creations that are produced through these partnerships that are part of the terms and condition of the funding. So again, it's complicated. Make sure you understand the nuances of your particular situation early on, and make sure those nuances are articulated for all concerned and that you're all on the same page, and wait for it, that page is written down. And then finally, and crucially, the nature and extent of your rights will depend on agreements among collaborators on a project or between supervisor and supervisee. Now, I want to highlight a general principle here that is a principle at the Faculty of Graduate Studies, and namely that we understand that a graduate student working on their own master's research project, so a thesis, an MRP, a graduating creative project, or a doctoral dissertation of any form or graduating doctoral project, the central research project of your degree, we understand that ownership and authorship of that work rests primarily with the graduate student. And agreements between supervisors and supervisees should not place undue restrictions or burdens on that authorship or ownership. Having said that, once you step outside your own dissertation or your own thesis or your graduating research project, it's going to be very important that you have agreements in place for work you're doing as an RA for your supervisor or other forms of collaboration. So that was a long list. Remember, the takeaway is it's complicated. Make sure everyone's on the same page and make sure that page is written down. The last thing I want to cover here is just to say, the bigger question, when and why should I care about my IP rights? For some of you in some fields, for example, fields like mine, the main way in which it will be important is just asserting authorship. And knock wood, this won't come up very often. Your name is on your dissertation. Once your dissertation has been passed through defense and approved by an external examiner and uploaded, that has the status of a publication, not for sort of peer review or things like that, but it is understood to be your work publicly recognized as yours, and that's important. For other work, particularly if you're engaged in research creation or creative work, or if you're doing sort of producing other kinds of material, copyright may be very important. For those of you involved in STEM in certain ways who are involved perhaps in looking at genetically modified organisms, at chemical formulae, at new processes or methods and so on, patents may become important. And that is where it becomes very important to know what tools are available to you at York, and in particular, tools like the IP Innovation Clinic, where you can start to talk about what does it mean that I am bringing something new into the world, that I am inventing something that is unique, novel, and unobvious to those in my field, and how do I ensure that I have the appropriate protections for this? Your supervisor will be a huge help here, but so will Joe's clinic, the IP Innovation Clinic. Joe, is there anything you want to say right now before I sort of move forward to talking about research with Indigenous peoples?
Yeah, thank you. I think that was actually a perfect segue right there. Looking back to what you had said earlier about it being complex or difficult, and it really is more so that it's specific to the situation and the specific creations, the works, the inventions that students or creators or authors are working on. And the different forms of intellectual property would come into play in different ways that you sort of alluded to. And then also just keeping in mind that the aspects of intellectual property, like any sort of creativity, especially from a copyright perspective, could be where a copyright protected work is created. It's not necessarily that it has to be amazing or fantastic or earth-shattering and extremely novel. Any sort of improvement on the state of affairs or creativity or the state of the art could be eligible for IP protection.
Thank you. That's helpful. That's true. I didn't want to inadvertently build up the threshold too high. Absolutely. You don't need to be Mozart to be thinking about your copyright. Thank you for that. So there's one other area that I want to touch on before we move into sort of some of the tools that can help you avoid conflicts and then what to do if you don't avoid them. And that is research with Indigenous peoples' knowledge and cultures. Now, York is actually sort of a leader in this area, in that the Faculty of Graduate Studies Intellectual Property Policy goes into detail about specific considerations around research with Indigenous peoples. And these are very much drawn from the UN Declaration on the Rights of Indigenous Peoples, and in particular, Article 3.1.1, that highlights that Indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions, as well as the manifestations of their sciences, technologies, and cultures, including human and genetic resources, seeds, medicines, knowledges of the properties of fauna and flora, oral traditions, literatures, designs, sports, traditional games, and visual and performing arts. They also have the right to maintain, control, protect, and develop their intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expression. Now, this is a really important part of both research ethics and understanding IP and how we do York and how we do research at York. It's very important to who we are as a research institution and to our values. And I'm sure all of you share in these values and these commitments. So I am not going to trample all over it by trying to summarize it in 3 minutes now. What I am going to say is if you think your work is touching on um, questions or issues or any of the different kinds of knowledge and technologies listed here, or if you will be working with Indigenous communities, Indigenous individuals, or traditional knowledges in any way, please consult two things. The first is at the Faculty of Graduate Studies, and those are our extensive guidelines about IP considerations for research with Indigenous peoples and communities. And the second is on Allison's site, the Office of Research Ethics, that because it is very important to know that all research involving Indigenous peoples and knowledges at York is governed by the Indigenous Research Ethics Boards. And there are processes, procedures, guidelines, and considerations very specific to this research that must be followed. As an overview, what I will say is it's important to recognize that for any of this research, all intellectual property is deemed to be owned collectively by Indigenous communities as a group and cannot be otherwise commercialized or reproduced without their consent. That's just a no-go. It is important that any Indigenous peoples and communities involved in your research control how information about them is collected, used, disclosed, and destroyed, have access to information and data about themselves and their community, regardless of where that data is held, get to manage and make decisions regarding who can access their information, and maintain stewardship of that data through possession, namely the mechanisms that are needed to assert and protect ownership and control. The data must remain in their jurisdiction and control. And, thinking back to that land acknowledgement and the history that York is bound up in and that settler Canadians like me are bound up in, I think we can understand just how important this autonomy, this stewardship, and this assertion of control is over the life, livelihood, cultural protection, and frankly, sovereignty of Indigenous peoples. And so I encourage all of you, even if you're not doing research, to read up on data sovereignty and Indigenous peoples, but also to consult these guidelines both at FGS and the Office of Research Ethics. So those are some general things about IP. Now, Joe and I have both said it's complicated, it's specific. What do you need to do? Have these conversations. Let's be honest, those are going to be some scary conversations. So here are some things that can help. How do you navigate IP? Well, you do it by talking about it early and often and making sure you're talking about it with any collaborators and most of all with your supervisor. And that means both your graduate supervisor and any PI who is supervising research work that you are doing apart from your primary graduate studies, and your supervisory committee to a lesser extent, but your supervisor and any collaborators. Joe, do you want to jump in?
Yeah, thank you. I just wanted to, I'm at the law school currently, so I should bring that, I guess, law school frame of mind to things. It's good to have these discussions. It's necessary to have them and to have them early and often, but it should also be in a controlled setting. Disclosure of what you're working on, your inventions, your works, could impact and negatively impact your IP rights or your opportunities for certain forms of IP in the future. So having these discussions in safe and confidential spaces and trying to get it on paper, as you said earlier, to try and avoid disputes and situations in the future. So making sure that you're really disclosing on a need to know basis as much as possible and potentially getting other types of agreements to help paper over and provide some more security and certainty there.
That's great. Actually, that beautifully feeds, thank you, because that beautifully feeds into the two tools I want to talk about, and in particular, the importance of using them in the order that I have listed them. So that's great, thank you. Because these are sensitive issues and because these are topics that, as Joseph has said, get to the heart of what you're doing and could potentially, disclosures could open you up to some sort of vulnerability. One of the things we've done in the Faculty of Graduate Studies is design not just the ultimate memorandum of understanding you might want to sign, but first IP awareness checklist that in a sense takes you and your supervisor through the principles of IP and the importance of understanding how we consider it at York first before you get to talking about what you're working on and so on. It is in a sense lining you and your supervisor up on the same page to make sure that you have both reviewed the FGS regulations, reviewed the CAGS, the Canadian Association of Graduate Studies Guide for Intellectual Property, reviewed the FAQs at York, reviewed the appropriate articles in the UFA collective agreement. That's the collective agreement governing full-time faculty and their research at York, and the conflict of interest regulation. So the checklist is 2 pages. It first asks both parties to sign off to say that they have read, reviewed, and discussed these with one another. And then the second page is really about building consensus and a shared understanding of what themes are covered in these, namely authorship, ownership, the impact of any funding agency who's involved, terms and conditions, any industry sponsors, and again, identifying and discussing any conflict of interest disclosures. We recommend using this checklist and sort of both signing off on it and having those conversations before you get to the topic of the second document. And the second document is now the agreement. So we have conversation, guidance, understanding. And then the second document is really about the agreement that you come to once both of you are on the same page about the kinds of considerations that Joseph has articulated, and also the principles that we take to be shaping and framing this conversation at York. So once you have done all that, then we have an IP Memorandum of Understanding between graduate students and graduate supervisors for all scholarly research and creative work. This allows you and your supervisor to spell out in more detail what ownership, authorship, potential co-authorship or co-ownership looks like in your specific circumstance and is agreed to and signed in paper by both parties. I would strongly recommend using these, especially if you take yourself to be going into the areas of creating something that could be owned through copyright or a patent, but also to use them in this order. Start with the IP awareness checklist. Make sure you're both on the same page about the principles, about the understanding, about the ways in which we prioritize graduate students' ownership over their own master's or doctoral work, and so on, and then come to the MOU together with that understanding. Now, these templates are general for graduate student work, and they're going to be useful for everyone. But if you are in a situation where you think there are, for example, industry or other public applications of the work you are doing, if you start to think, no, we are making something, these fall under the category of invention in some sense, we are going to need to be talking about in patents and so on. This is where you leave the shores of FGS and head over towards innovation, both at Joseph's clinic, the IP Innovation Clinic, and then more broadly looking at Innovation and Partnership York. And both links will be provided in the chat and can be found on the page. And is there anything you want to say about that at this point, Joseph?
Yeah, feel free to use our clinic as a touch point. We work closely with the Office of the VPRI in Innovation York and MySpace, all our partners and collaborators across the campus. So you can reach out to us for that sort of one-to-one discussion, and we can help guide to the appropriate resources and assistance.
Good, thank you. Thanks for that. So all of you are here today. All of you are hearing this. And ideally, all of you have already found and downloaded the IP awareness checklist and the MOU. You are going to bring them in your hot little hands to your supervisor at your next meeting, and everything is going to be smooth sailing from there. But I do want to talk about what happens when things go wrong, and also ways in which IP bumps up around other aspects of research integrity, research ethics, and appropriate research conduct. So I'm going to say a little bit, and then I'm going to turn things over to Allison. So what happens when things go wrong? We do, in fact, have a dispute resolution process at the Faculty of Graduate Studies. What I mean by this is when there are multiple parties in some sort of research collaboration, whether it is the one we envisage is student supervisor, but there may be others, whether it's co-authorship among graduate students or collaborations among research faculty that involve multiple graduate students and so on. Sometimes things go wrong and one party may feel that their IP rights are not being respected, or they have an IP-based claim against some other party in the collaboration. What do you do then? So as graduate students, your first stop for this is your first stop for everything, and that is your graduate program director. If you are able and feel comfortable to resolve this at the program level, that is always the best step for a couple of reasons. First, it keeps it local and small, and as Joseph has already indicated, there are vulnerabilities to talking about IP, and we recognize that. Second, your graduate program director is likely in your field or close to your field and has an understanding of the disciplinary norms, conventions, colleagues, and so on involved. They may well be able to negotiate some sort of resolution among all parties. If the case cannot be resolved at the program level, the GPD, that's the Graduate Program Director, should contact the Dean of FGS. Right now, that's me. Or the Associate Dean responsible for graduate studies in your anchor faculty. That's a term that in admin we totally get, and you may not. Your anchor faculty is like your subject area faculty, so education, science, engineering, liberal arts, fine arts, and so on, AMPD, I mean. That's your anchor faculty. Each one has an associate dean who is responsible for grad. Your GPD can talk to them, or they can talk to me. I will say if your GPD talks to them, what they're going to do is bring it to me, so it ends up in the same place, but it can go either route. At that point, I step into the dispute resolution process, and my first step is to consult widely, including speaking to all parties to, again, attempt to find a mutually acceptable resolution, talking to everyone involved, relevant others, seeing what can be worked out. If an informal resolution cannot be found, I then form a panel of subject matter experts. This confidential panel is typically composed of folks who are experts in the subject matter, so in the particular research area, and also experts in IP. As you have already gathered, we have a lot of really extraordinarily world-renowned experts in intellectual property at York. So this isn't as hard here as it might be at some places. We will then gather all possible materials, testimonials, letters, information related to the dispute. The panel will review on it, adjudicate, discussion. At the end of this consultation with the panel, I will make and communicate my decision to all parties. Ideally, at this point, some resolution will be found. I will be honest, this process is lengthy, it is complex, and it may not always offer the result that you want. This is one of these difficult things, and because IP is so complicated, and because many people go into activity where IP rights may come up, not having a full understanding of what IP rights are, once we get to this stage, there is inevitably going to be some sort of disappointment or frustration because there are conflicting and incompatible understandings of what the collaboration was intended to be. So someone is going to end up disappointed. It's for that reason that I kept saying, know the specificities of your situation, make sure that everyone who's necessarily involved is on the same page and that page is it's written down. I strongly recommend using the checklist and the MOU to avoid disputes before they arise. Any dispute that does arise, I and my extraordinary team at FGS will throw ourselves into it. We will likely be consulting with these very experts along the way and have done so. But crucially, the best dispute is one that doesn't arise. So I highly recommend using these tools, and that's why we've put so much work into developing them. Allison, now that I've invoked you, I'm going to turn the page and can I leave it to you to talk a little bit about how IP fits into the topography of research?
Thank you. And I also want to echo your comments that these tools are fantastic, what you've just outlined, the checklist and the MOU, and I cannot say this strongly enough. Please use them because I see the other side when things go wrong. And to, again, echo what you were saying, the vast majority of the time, you're not going to get the outcome that you had hoped for. When things go off the rails, especially if there's no written agreement or written understanding, it's a very lengthy process and one that does not generally provide you with the outcome that you would hope for. And often folks see the ethics office as like the gatekeepers. They're like, well, ethics can fix it. They can address this. And, especially if there's an accusation that, one of their colleagues has behaved unethically. That may be the case, but that is not our role. The Office of Research Ethics provides oversight of research involving humans, animals, and biological agents. Ethics writ large is not our purview. Whether someone is behaving ethically or not is not a research ethics matter. So when you're speaking, I'll leave aside animal and biosafety, but for human ethics, the approval process focuses solely on the participants' rights, the risks to the participants. What are you asking them to do? What is the kind of data you are collecting? What are you doing with that data? What is the ultimate disposition of the data, right? So we look at everything within the context of risks to the participants, not the researcher. We're often asked that as well. You know, the researcher wants to do something very, very risky in a, you know, politically volatile environment. You know, the risks to the researcher are not within our purview. The risks to the participants are. So IP rights, the focus is on the PI, right? The protection of their intellectual property or their inventions. So I want to be clear, should something go off the rails, ethics approval does not confer any IP rights to you as a PI. Even if you're the PI and your faculty advisor is a co-PI or you know, just a team member. If there is a dispute, you can't look to or turn to the ethics protocol and approval of said protocol to help resolve an IP dispute. We can help inform the process, but we're not the ones who can help resolve the problem. So going back to your comment, Alice, please use a check. I always say to students, do you have anything written down? You know, I also say just looking at the data part, which I guess is in essence a product of IP. You know, a lot of times research students are doing their research under a faculty member's protocol, ethics protocol. So they've got a TD4, but the student is doing all the research. They're doing all the work. And then unfortunately, there can be a breakdown in the relationship and there's a dissolution of that relationship. Then the student, if there is no agreement in place, the student no longer has access to that data because the protocol is not theirs. So these kinds of things, those are some of the most common pitfalls that I see. And in terms of process, once you've exhausted this dispute resolution process, if the student does have another process, which is my other hat, I'm also the director of research integrity for the university. You can launch an RCR complaint. But again, if there is nothing in writing and there is no checklist, MOU, etc., this process is very lengthy. And again, it is a blunt instrument, let's just say, and an imperfect tool if you're seeking to resolve an IP matter. So it's a very long-winded way of saying, you know, we can do our best to assist you, but these are great tools. I would use them.
Yeah. Thank you, Allison. No, I really appreciate that. And what I really hear you saying is think of the tools as not just helping you, but also helping those of us who might come in later and want to help you. It helps us help you as well. And I think that's a nice way of putting it. Thank you.
I've had to deal with some really unfortunate student situations. And, you know, there's just been a bit more effort at the front, you know, at the start. The outcome could have been different.
Yeah. Yeah. And I think all of us on this call really want to highlight, we're always rooting for students.
Yeah.
And so it's very hard when we can't turn that rooting into results. And so again, help us help you with these tools is a big one. Yeah. Well, I do want to open things up. I have some questions, and I imagine that others have some questions too. What I am going to do, partly just so, because sometimes faces are nicer than slides, and also so that I can see the Q&A, is I'm going to stop screen sharing briefly, and in order to do questions, and then I will put the screen back at the end just to sort of do a summary or an overview of the various resources that we provided so you can have them. But for now, I will stop sharing my screen. Excellent. And I thought I might just start with maybe, Joseph, I could just ask you a question. So we covered this a little bit earlier, but I think some students may have questions, namely, at what point should a graduate student consider reaching out to you, to your clinic or elsewhere for support? Is it when they first have an idea for a project, at the beginning, at the sort of proposal stage, once they've made it and they realize there might be something in it? Can you say a little bit more about when they should click on that link and so on?
Yeah, sure. And this goes back to what you said earlier, early and often, like as soon as possible. Like it doesn't have to be something where you've already got a prototype or a manuscript already put together. You might just be thinking about a new project that you want to look into. And the way that we look at intellectual property is something that evolves with the research project or a business project, and being able to use the different tools to your ends. So reach out whenever, as long as we got capacity. We're always available to have discussions and see how we can help and answer questions, and then revisit the conversation as things develop, as new considerations or as new collaborators come into play.
That is helpful. And Allison, you sort of answered this, but at what point do students reach out to you? Is it after they've exhausted the FGS process as an alternative to it? When should students be reaching out to your office if they think something has gone wrong related to this?
I mean, I would advise students to reach out to us at any time, and we're here to answer their questions. And I think it's often helpful for them to reach out to us to clarify what we can do, and more important, what we can't do, so that they don't spin their wheels hoping. They can also consult with me wearing my other hat, research integrity, if they feel that there is a breach of the scholarly framework on responsible conduct of research. They can reach out to my office. Usually it's invalid authorship or inappropriate authorship. So they can reach out to my office for a consultation on that. Speaking obviously in generalities, because if it is an actual complaint, then I would need to be, there is a specific process. But so we're here to help students. I always use the same term when I'm giving presentations to student classes. We're not the ethics police. Our job is not to stop research. Our job is to facilitate compliant research. So if you've got a question, we're here to help you.
I love that. Thank you. I'm glad to know you're not the ethics police. Actually, you've just partly answered one of the questions we had from the audience. Someone wanted to know what RCR was.
Oh,
if you could
sorry.
explain a little bit about that. So you've mentioned the full title now, but maybe you could say a bit more.
It's the responsible conduct of research, which actually isn't very sort of intuitive. It's old-fashioned term was misconduct, research misconduct. So the standard list of, plagiarism, data manufacturing, invalid authorship, or breaches of various tri-agency policies, humans, animals, biosafety, security, mismanagement of agency funds, that kind of thing.
That's helpful. Thank you.
Apologies.
And no, not at all. Listen, getting used to acronyms is a sign you've been at York too long, and we all need to check ourselves. There was a good question, a process question. So I have been introducing these two tools, the IP awareness checklist and the Memorandum of Understanding. And someone was saying, are these tools that are required and need to be filed with FGS in order to graduate? And I really appreciate this question because the answer is no, and I want to make that clear. So there are, many of you will know FGS largely as the keeper of forms, and I realize we have a lot of them. And at various points in your graduate school journey, there are, well, now there are less forms and tend more to be web-based things that you have to do, but you have to file things with us. You have to say, here's my proposal. You have to tell Allison's office, here's my research ethics protocol. You have to fill in your sort of request to go up for defense and so on. These aren't one of those forms. These are not required for graduation. I don't yet know of any graduate program that has made them mandatory. If a program did, if it was a program that had a lot of sort of research creation or other kinds of inventions or sort of potentially patent protected items in it, I would encourage that. But at this point, no one has made these mandatory, and you don't need to file them with us or anywhere else in particular. Just make sure you save a copy. These are tools we are offering to you and to your supervisors to help you ensure that you are following best practices when it comes to engaging in collaborative research, and in particular, having a shared understanding of the IP rights over the products of that research. So this is not something that has to be filed with us. You are welcome to reach out to FGS or to the ORRE to ask questions, or indeed to the IP Innovation Clinic to ask questions. If you're like, I'm not sure how my supervisor is filling this out, I want to ask a question, we would all be great people to check in with. In fact, I would, on my screen, it goes Joseph, Alice, and me. And if I had to rank our understandings of this process, that is also how I would rank it. So I would encourage you to reach out to them first. But you're welcome to consult with us or ask us questions. But this is a tool for you. This is something that we are providing to you to help you to help you think about your rights, identify things that you might have rights over, or that you might potentially have rights over, and then to protect those rights as best you can. So that was another question. And then there was a question that is tangentially related to IP, but Allison, since we have you, I'm going to read out this question as well, because everyone wants to know about ethics. So this is, what about a master's, where a portion of the master's requirements is the creation of a film, and the film includes participant interviews with consent. If the researcher wanted to make the film available to other scholarly places or the public, presumably they would need consent from the participants. Is York consent also needed? If a film is made at York, is it somehow owned by York, or is it just necessary to follow research participant consent?
That's a very, very complicated question.
Mm-hmm.
Because if it is a film, is it an artistic work or is it research, right? If it's an artistic work, then it wouldn't come through my office at all, even though there are participants in the film. If, however, there is a component of research in the creative work, then ethics review will be required, and they would need to get a certificate of approval. And in their consent form, they would need to outline, as best they can, the potential future uses, right? So if they intend to broadcast it at the film TIFF, for example, so they've done their thesis, they've defended, and now their film is considered so great that it can be showcased at TIFF. That would need to be clear in the consent form that those are the future purposes.
Okay, that's helpful. Joseph, is there anything you want to add to this, maybe about the artistic side of things, or?
Yeah, just from a copyright perspective, like the copyright is with the creator. So you'd be looking at the person that's actually doing the recording of the video that goes into the film. So there's going to be a whole host of questions about what the content of that is and whether there's any rights of other copyright protected works that might be included in a video, and then other rights that the subject of the video might have, which I think is more some of the stuff in that question as well. So this is really one of those areas where it does become complicated. Like the copyright of the recording itself is separate from other types of rights that might be impacted as well. So that is, it's a big question. And one of
Yeah, this
those
is
where
one
it's
of those
best to get
cases where the
offline.
specificity,
Yeah.
yeah, I was going to say, at the risk of failing to answer all of the questions that are out there, it might make sense that this is a good question to take offline. And again, I think we've sort of given you the possible routes for answering it. I would encourage you to start within your program with your supervisor in the GPD, and they can then direct you to appropriate experts in ethics and on other questions, whether those end up at FGS, the ORE, or the IP clinic. I think you can be directed there. And actually, this is a wonderful case study to demonstrate how limited our general advice can be in this area. How our main advice is, if you like, meta advice. This is why it's complicated. This is why it's important to ask these questions early. This is who you can ask them, and here are some tools available to make sure that you're protected. And that is sort of the best that we can do. I know we are quickly coming to the end of our time. I think I wouldn't mind posing a question to each of you, Allison and Joseph, and you've answered this a little bit along the way, but is there anything that you wish was better known about sort of the role of research in the role of IP in scholarly research, or how to think about ownership and authorship and these big questions as we engage in scholarly research, particularly in the context of graduate research, but perhaps more generally? And I'll start with you, Joseph.
Sure. There are many things that I wish grad students knew about IP, generally speaking, and not just grad students, but also faculty, researchers, people from outside the university community as well. That's really one of the reasons Professor D'Agostino started our clinic, was to help give those resources and that information. And for the context of this discussion, though, I think the main ones are that what we do is intellectual property. That is what we create, whether it's something that's an artistic, visual, literary work that's protected through copyright, whether it's something that's an invention that is going, that could be potentially patentable. Different forms of intellectual property are there to protect and help the creator and the owner of those rights advance their goals in different ways. So what we want to do is help equip our, we call them clients, because we're structured as a little law firm, is to give you the tools to know about what your IP is and how to use it. And that's kind of my second point is, what do you want to get out of your research work, your graduate education? What is it that you're creating now, and how do you want to use that in the future? Because what you do and how you look to leverage and protect it will really help put you in place to do those things in the future. So. And that can be commercial goals, that can be non-commercial goals, but IP is a tool that you can use to advance your research and your scholarship and your own mission and work going forward.
Thank you.
Just from I'll just add a little bit from an ethics perspective. IP for in a broader sense of the terminology, it's just understanding what IP is, changes across disciplines. So these agreements are critical because some disciplines, kinesiology, for example, where you're working in the lab, it's very, very vague and blurry as to who owns this data, for example, right? You're generally working for or under a faculty member. So students are often upset towards the end when things go wrong. It's like, but I did all of the, I did all of the studies. I collected all of the data. Yes, but the initial idea was not yours, right? So understanding what your role is in the research and what intellectual property would mean in that context is critical so that there are no upsetting or disappointing things, towards the end. Yeah.
Yeah. And that's such a helpful reminder because there's disciplinary norms. There's also, of course, sort of whose research project is it? Whose grant was it under? Is it for your academic studies or is it part of something else that you're doing extracurricular or in your role as an RA? Whose names are on the sheets and so on. All of this plays such a role. And I think all of us are used as scholars. Our first instinct is to think about research as, idea, method, analysis, do the actual works, get the results, talk about it, write about it, and so on. And we forget to think about it as a project that is managed, as something that is funded, as something that is structured in an institution, and all the different kinds of ownership that come in once you start to unclaims, once you start to think about it that way. And it can feel a little bit disillusioning, but also empowering to know that these things are in play and to be aware of them and thus to be able to navigate them well. Yeah. I really appreciate this, both of you. We are just wrapping up here. What I am going to do is I am going to make sure that I have shared the useful links. So I'm going to turn my PowerPoint back on and just click through these. I think as you can see here, we have mentioned the FGS policy on intellectual property and graduate education at York, the IP Innovation Clinic at York, as well as Innovation and Partnerships at York. Allison, I have not put your office on here and I apologize for that, but I strongly encourage absolutely every graduate student to have a link bookmarked to the Office of Research Ethics, to know their policies, to know their processes, to know who they are and how to reach out to them, to keep an eye on their drop-in sessions and their consultations that are available also because they have office hours and these are phenomenally helpful. We also have our FAQs on intellectual property and graduate education. And then stepping beyond York, the Canadian Association of Graduate Studies has written a guide to intellectual property for graduate students and postdoctoral scholars. I have relied on this in my learning around this topic, and I encourage you to do so as well. So I'm going to wrap up now. I want to say an enormous thank you to both Joseph and Allison. I really appreciate your time and your expertise today. This is a topic I have wanted to cover for some time, but knew that I couldn't do it on my own. So thank you so much to the two of you. For those of you who are attending, thank you so much for coming. This is the first Scholarly Skills webinar of the 25-26 academic year. It's not the last. We have upcoming webinars on artificial intelligence in graduate research, on using primary sources and archival contexts, on shifting from imposter syndrome to growth mindsets, on navigating your graduate academic milestones, and on project management. So really every aspect of research that you could think of. I also encourage you to check out the FGS website and our YouTube page, because we have all our past Scholarly Skills webinars archived there. And there you can see webinars on everything from getting over your fear of the conference spotlight, publishing your work, starting a major project from scratch, navigating the ethics protocol. I believe Allison also features as a guest star on that one. Putting your stress to work, and other aspects of managing academic life. So please join us for future Scholarly Skills webinar. Thank you so much for coming today. And I would be remiss and in big trouble with my communications director if I didn't also ask you to stay updated by liking, and subscribing to York UFGS. Thank you so much, Allison and Joe. Have a good day, everyone.